this term we use for judicial intervention. So it can be done, judicial intervention can be done for various purposes. But two major purposes are there: justice and harmony. Okay. And justice can be punitive in nature. It can be punitive in nature. That means for the purpose of punishment. It can be corrective in nature. Apart from that, when justice is related to harmony, sorry, judiciary is related to harmony, it is related to, this is concerned with distributive. So simply judiciary exists for adjudication. Adjudication serve the purpose. Its purpose of adjudication is justice and harmony. Justice can be punitive to punish a person if he is culprit, because it gives relief to the psychological relief to the victim. It creates a moral pressure on the criminals. It creates a confidence in the common man. So justice punitive, justice corrective, and harmony, social harmony, balancing society, resolving conflict between various bodies. How it can be done? So it is distributive justice, means resources of a nation, resource of a society must be equitably distributed. So justice, when brings social balancing, we say social justice, it is distributive in nature. When it brings economic justice, it is distributive in nature. So harmony is created by the process of equitable distribution or redistribution of income and wealth, and that can bring social and economic justice. So harmony is nothing, it's a kind of creation of a society full of justice. Okay, so this is basically, this is substantive. Harmony is a kind of substantive approach to justice, and this is procedural approach. This particular is a procedural approach to justice. Is not that procedural and substantive law, that is different. It's a procedural approach, it is substantive approach. In substance, justice comes. When harmony comes, harmony is a very comprehensive term. It can be harmony between me as a person and my body as a physiology. And there can be harmony between me and external world. It can be environment, it can be my family, it can be my relatives and friends. There can be harmony between one family, neighborhood, harmony between one community, caste, other community, caste, one religion, other religion. There can be one mohalla, other mohalla, one village, other village, one city, other city, one state, other state, one nation, other nation. Harmony of earth in relation to moon, sun, it's a very comprehensive term. And judiciary can have its role. It can adjudicate to bring harmony. When some harmony is broken, like you see cases of MC Mehta versus Union of India case, 1987, 1997, 1999. MC Mehta case, Supreme Court talks about right to potable drinking water, right to pollution free environment. MC Mehta is an environmentalist who fought for clean environment. That PIL very popular. And Murli Devda versus Union of India, smoking in public place becomes offense, 2002 I think. Various cases in which court talks about environment and human beings good relationship. Supreme Court rules to create a green tribunal. NGT created after Supreme Court's ruling. So court can take up any type of harmony. Harmony is a very comprehensive term. Harmony is not a direct form of justice. In substance, justice gets exist. And when there is talk about trying cases, criminal cases or civil cases where penalty can be imposed, criminal cases where punishment can be given. So that is a procedural in nature. Procedural in nature. Now, whenever we talk about when can court intervene, when the question comes when can court intervene, we are talking basically about this. Because as far as substantive justice is concerned, substantive approach to justice is concerned, court can intervene anytime, anywhere, anyway. Court has unlimited power to intervene in case of this substantive approach. But in procedural matters, in procedural approach to justice, court intervenes court's intervention so first, abuse of power. Second, lack of jurisdiction. Lack of jurisdiction. Third, error of law. Fourth, error of fact finding. Fifth, procedural errors. Abuse of power, we call it malfeasance. Lack of jurisdiction we call overfeasance. And these three are called misfeasance. Abuse of power means anybody is misusing power for personal reasons. Overfeasance, lack of jurisdiction, means an authority is acting without power to act. They don't have jurisdiction, they don't have power, but they act. Error of law. So law is not as per constitution. Law is not as per the basic ideas of constitution. Or one law becomes contradictory to another law. Error of fact finding. That happens. A person, there was an investigation of the crime and person found guilty was punished. But the punished person's lawyer approaches higher court. So again inquiry, re-inquiry is done. So it's done on the basis of assumption that fact finding was errorful. That point of error was highlighted by the lawyer for the purpose of appeal. So without this error, appeal will not be accepted. As error is existing, the lawyer appeals and court accepts. And there can be procedural error. Means there should have been a case filed in a particular court. That court is not competent. Or charge sheet was not filed in a particular way. FIR was not lodged in a particular way. So if the procedure related laws are not followed, like CRPC is not followed, Indian Evidence Act related procedures not followed. So when the procedures of law are not followed, then court will intervene. So court intervenes in these 5 circumstances. These circumstances are related to the procedural approach to law. When here when justice is related to punitive corrective, otherwise you see harmony. This for this purpose, in India we have a particular mechanism called PIL, public interest litigation, for any purpose. There is no case of abuse of power, lack of jurisdiction, error of law, error of fact finding, procedural. Despite all these, there is absence of some law for some purpose. There are some conditions because of which humanity gets victimized. Condition because of which some caste gets victimized. Condition because of which some particular class of people gets victimized. Any case where social harmony gets disturbed, harmony of man with environment gets disturbed, harmony of 2 countries, 2 states, harmony of a family gets disturbed, harmony of relationship among social groups get disturbed. Any case where harmony is disturbed, court can intervene, and that is you say infinite, boundaryless. However, when we study about the jurisdiction of the court and the conditions in which the court intervene, basically these 5 procedural cases are referred. Okay, so these are the background or cases under which judiciary intervened.